All right, this is the Tessa Chlorine Mau versus Zachary Lee Mau, and it is for final hearing on the divorce action that's been filed in this case. And Mr. Mau, you're representing yourself pro se. There's no, I don't believe there's an answer that's been filed.
There has not been an answer filed, Judge.
Right.
Due to the fact that he is in jail, we did not file a default, but it will be similar to a default as we present.
Our appellate courts have ruled that even though you're incarcerated, you have the right to have participation in this action, but because you have not filed an answer, it will be limited to observing what takes place at this point in time. Right. Ms. Duke, you wish to put on your proof if you want to bring, are there any other witnesses?
There are no other witnesses. It's Ms. Mau today.
Can we bring Ms. Mau for her testimony up since she's in a wheelchair to the
Absolutely.
witness block? You'll come around, Ms. Mau. We're going to ask you to.
If you would, please state your full name for the record.
It's Tessa Chlorine Mau.
Ms. Mau, you are currently married to whom?
Zachary Mau.
Okay. And Mr. Mau is currently incarcerated, is that correct?
Yes.
Okay. And is he incarcerated due to the, and you just say yes, on July the 1st of 2024, he attacked you, is that correct?
Yes.
And as a result of that attack, you almost died, is that correct?
Yes.
You have been rehabilitated, is that correct?
Yes.
Okay. And is this in fact Mr. Mau here on the video screen?
Yes.
Okay, and he is in fact the one who attacked you, is that correct?
Yeah.
Due to the attack, are you, have you incurred significant medical bills?
Yes.
Okay, significant time away from work?
Yes.
Okay, significant time away from your sweet boys?
Yes.
Okay. And have you had to go through very painful physical therapy?
Yes.
Okay. You had 9 stab wounds, is that correct?
Yes.
Okay. And when they transported you, they had to transport you on your stomach, is that correct?
Yes.
Because of a knife that was in your back.
Yes.
Since that time, have you, were you also set on fire on that date?
Yes.
Okay. But you survived those injuries.
Yes.
And are you asking the court to consider the things that we've just gone over in awarding you the assets in the marital estate?
Yes.
Okay. And the only assets in your marital estate due to the fire at the residence are the residence itself, which is in a dilapidated state right now, is that correct?
Yes.
And 2 vehicles, which the court has already given you permission to sell, is that correct?
Yes.
Okay, the truck and your vehicle. You've retitled those vehicles at this point in time, is that correct?
Yes.
And your vehicle, the car, has got a lien on it still, is that correct?
It is.
Okay.
Yes.
And you're working to get that paid off.
Yeah.
Okay. The home has still got a mortgage on it, is that correct?
Yes.
In a perfect condition, how much would you tell this court that that house is worth?
About 300.
Okay. And your home, did homeowners deny your homeowner's insurance as a result of the fact that that your husband set fire to the home?
Yes.
Okay. Are you asking this court to take that into consideration when he's awarding the marital estate, when he's dividing the marital estate?
I'm sorry, did you say the insurance company has denied the claim for insurance because it was an intentional fire by?
Because it was arson. Yes, sir.
What company was that? What was your insurance company?
I believe it was State, Allstate or State Farm. I
I
can
want to
look.
say State Farm.
Doesn't really matter, I was just
I
curious.
believe it was State Farm, Judge. And at this point in time, the house in the condition that it's in, is it worth probably less than what's owed on it?
Is it worth less?
Is it worth less than $180,000 because of the fire that was set on the inside of it?
I want to say that.
Okay. And do you know about how much in damage, how much it's going to cost to repair that home?
About 50 to 70,000.
And after that, there probably will be $25,000 to about $30,000 in equity. Is that correct? Okay. Based on the fact that Mr. Mau is in jail and looking to be sent to prison after a subsequent criminal trial, are you asking this court to award you all the equity in the marital residence and all of the value for the vehicles as your child support and any spousal support that he may be required to pay?
Yes.
Okay. Prior to him going to jail, was he earning approximately $60,000 at Dial Tile?
He was.
Okay. And you say approximately because that is he was never very forthcoming with what he was making. Is that correct?
Yes.
Okay. And you believe you would be entitled to more than just the equitable portion of the estate for child support purposes, but you're asking the court to award you the house at this point in the vehicles. Is that correct?
Yes.
At this point in time, do you know, was Mr. Mau honest with you about anything he was doing with retirement? Do you know if he has retirement?
I just knew he just started late.
Okay. And are you waiving your interest in any retirement at this point? To his retirement? He had like $300 in it, is that correct? Okay. Are you asking that the court allow you to keep your retirement?
Yes.
Okay. Is there anything significant in your retirement at this point in time? Okay. Now, there was a GoFundMe and some other things some other monies that you collected due to your injuries. Are you asking the court to award those to you?
Yes.
As having occurred after the fact and they were raised specifically for you, gifts to you? Okay, they are separate property, they are not his property, is that correct?
Yes.
Now, on to the very most important thing in this trial today are your children. Are you asking that this court awards you sole custody of your minor children?
Yes.
Okay, and that is Jackson and Carter Mau, is that correct?
Yes.
Okay, and are you asking that this court maintain there is a order of protection in place based on the injuries that you incurred? Are you asking this court to put down a permanent injunction preventing Mr. Mau from having any contact with you or your children?
Yes.
Okay. Are you asking that pursuant to the parenting plan that you be awarded all holidays, all visitation, all the tax deduction, that if Mr. Mau were to get out, are you asking that Mr. Mau be required to carry a life insurance policy on himself for the benefit of your minor children?
Yes.
Okay. Are you asking this court to make sure that if Mr. Mau does get out, that Mr. Mau start paying child support for these minor children?
Yes.
Okay. Is there anything else you'd like to ask this court to award you as far as the children are concerned? Are you asking the court to prepare a separate order regarding what else we spoke about?
Their last names.
Okay. Are you asking that their last names be changed?
Yes.
Okay. Are we living in a very small community where that Mr. Mau's name is identified as being criminal in nature, and you're asking that your children be absolved of that?
Yes.
Okay. And you're asking that your children be named to your maiden name, is that correct?
Yes.
And are you asking that your maiden name be restored at this point in time?
Yes.
Okay, and for purposes of anonymity, we're not going to say your maiden name out loud, but the court's got it in their file. Okay. Are you asking that these minor children also drop their they've got 4 names, is that correct? 2 middle names for both of them?
Just the first one got the 2.
Okay. Are you asking that they drop the name Lee that is synonymous with Mr. Mau?
Yes.
Okay. Judge, that is our proof.
All right. Ms. Mau, my understanding is that because of the assault on you by Mr. Mau, that you sustained 9 stab wounds and that you were then, he set you on fire as a part of this attempt on your life. And I see that you're in a wheelchair today. Are you confined to a wheelchair or are you able to get around?
I'm confined. I can walk just a little, but it's everything I have.
Okay. All right. Well, it is unfortunate that we're having to have this hearing at all, but I will hear from any other witnesses. Do you have any corroborating witnesses?
I do. I have one back here.
Let's just let Ms. Mal stay where she is, and then we'll bring up the corroborating witness.
Well, and if you need to, Judge, I've got Miss Roberts. She can cooperate also if you need an extra one. But
So
I'd love
we're
to
going
put
to
her
place
under-
Ms. Roberts
I'd
under
love to
oath
put her
as
under
well.
oath.
Well,
Just
now,
so that there's not an issue.
I think I will be the judge of how limited we're going to be with questions. All right, both of you raise your right hand. Let's place you under oath. All right, Ms. Duke.
Ms. Roberts, did you hear everything that was said and everything that was testified to? And so you know everything that Ms. Mal has said today to be true and correct to the best of your knowledge? And it's in the best interest of the minor children to have no contact with their father and for Ms. Mal to be awarded the mess. It's a mess. If you would, please state your full name for the record.
Timothy Wade Trotter.
And Mr. Trotter, you heard all the testimony today, is that correct?
Yes.
And is it true and correct to the best of your knowledge, everything that's been testified to? It's in the best interest of these minor children to never have contact with Mr. Mal again. Everything else that Ms. Mal testified to, she's entitled to to the marital estate, and you've observed the condition of the marital residence and of the vehicles. Its arrest, and currently there's still all the value to some degree. The division of the marital estate is equitable, having been awarded to Ms. Mal. Judge, that's our proof.
All right, Ms. Mal, you can come back if you'd like. The court finds, based upon the proof in this court, that the wife is, or that the plaintiff wife is entitled to a divorce on the grounds of an attempt made by the husband on her life by means of malice, including the stabbing and setting her on fire. And that's a ground set forth in TCA 364107, subsection 7. It obviously constitutes the inappropriate marital conduct, but I think that prior finding is more appropriate. The real property that's located here has de minimis value at the present time because of the fact that it's in a state of disrepair. It's going to require expenditure of monies before it will actually be marketable in any event. The law requires that the court, in considering a division of marital property, to make that division fairly or equitably without regard to fault. And so I am stating on the record that I am making this division of what I consider to be a fair division without regard to the fault of Mr. Mowell and his attempt on the life of his wife. But because of that attempt on her life and the injuries that she has sustained and the damage to the real property that has been occasioned by Mr. Mowell's actions, according to the proof in this case, the equitable distribution of property is, in my opinion, favors the wife. And for that reason, I will award her all of the equity that may exist, if there is any, in this real property. She's awarded the title to the property, free and clear of any claims of the husband. Of course, that is subject to the mortgage interest. And I also would point out that part of my consideration has also been the fact that his actions, as proven by the proof in this case, led to the denial of insurance coverage on the damage to the property. Go ahead. And the two vehicles that were involved in the case represent the only other assets that the parties had. And for that reason, because of the medical expenses that Mrs. Mowell has incurred It is my opinion that all of those assets should be awarded to her to help to compensate for the medical expenses and so forth, and the damage to the real property that were occasioned by Mr. Mallow's conduct.
But we're also asking for attorney's fees at this point in time. I can submit an affidavit.
Submit your affidavit, but I believe she would be entitled to attorney's fees as well. He will be awarded the retirement account in his name only. She will be awarded the retirement account in her name only. Any monies that were acquired by the GoFundMe account that was set up following this event that led to her injury and hospitalization will be awarded to her as her separate property. Is there any other asset of property that I have not dealt with?
There isn't, Judge. They're young and had not acquired much.
All right. Then moving to the issue of the custody of the minor children, clearly Mr. Mallowell is facing an attempted first-degree murder case charge that is yet to be heard, and he's presumed to be innocent of those charges under the criminal law. But in this court, the court finds that the proof is established for, at the lower burden of, by preponderance of the evidence, that he did in fact attempt to take the life of his wife. And for that reason, the court finds that she should be granted sole and exclusive custody of the minor children. She will be designated their primary residential parent. I do not set any sort of visitation for Mr. Mallowell whatsoever at this point. If Mr. Mallowell in the future is released from custody and in the future chooses to try to have a relationship with his children, he will have to file something with the court to establish some sort of visitation. And for that reason, I'm not delineating any type of holiday or any other visitation. The children will be with Mrs. Mallowell exclusively. While I can only extend an order of protection for 1 year and then renew it year to year, I can issue a permanent injunction, and this court will issue a permanent injunction against Mr. Mallowell, who is, I'm sure, under bond conditions anyway under his criminal case. But that permanent injunction prohibits and bars him from any contact, directly or indirectly, with Mrs. Mallowell or with the minor children. Again, that would defer to any future order regarding any sort of contact that a chancery court or domestic relations court allows contact with the children upon his release from custody. But at the present time, he is not to be allowed to have any type of custody. The proof in the case is, as I understand it from the file at least, that the children were present during his assault on Mrs. Mallowell and tried to talk him out of doing the things he was doing. That's set forth in the complaint itself. And because it was a sworn pleading, I will take that as, and take notice of that. So based upon those facts, I don't think it's appropriate for him to have any contact with the minor children at the present time. Again, if he's released at some time from in the future or found not guilty for some reason, then he has the right to come back into court and to seek some sort of visitation with the minor children. The issue of child support is simply reserved. He obviously at the present time is incarcerated, has no ability to pay any sort of child support, and the court finds that a name change is in the best interest of the minor children as was requested. Based upon all of those factors, those are my ruling. Anything that I failed to address?
Judge, that is everything.
All right.
I did not bring a final decree over, not knowing how this would be handled
You'll
today.
prepare the final decree and submit it along with your affidavit of attorney's fees.
I will. Thank you.
All right.
Asterisk at this point in the courtroom, the tension is absolutely palpable. Tessa Chlorine Mau recounts the horrifying events of July 1, 2024, where her husband, Zachary Mau, attacked her, stabbed her 9 times and even set her on fire. The severity of her injuries is staggering. She now struggles to walk and requires a wheelchair. Legally speaking, the court doesn't just take these claims at face value, they weigh them carefully against evidence, witnesses, and the burden of proof. Civil courts operate under a preponderance of the evidence standard, meaning they only need to determine what is more likely than not, unlike criminal courts which require proof beyond a reasonable doubt. Now, the stakes rise even higher. Tessa is requesting ownership of the marital home, 2 vehicles, and even funds raised on her behalf after the attack. Ordinarily, marital property is split equitably without considering fault. But here, Zachary's intentional actions caused direct financial damage, destroyed the home, and even voided insurance claims. The judge can, and does, take this into account, ensuring that relief is both fair and protective. And then there's the custody issue. The children were reportedly present during the attack and attempted to intervene, which dramatically underscores the danger they faced. Tessa requests sole custody, a permanent injunction against her husband, and even name changes to protect them from long-term stigma. This is where law meets real-life stakes, protecting victims and children while balancing fairness, evidence, and safety. For viewers, think about this: how would you weigh property, finances, and child safety if you were in the judge's seat? This is civil law at its most critical, intense, and human. Asterisk.